On probation before judgment, probation agreements, probation, not deportation.
Is on third reading and final passage. Is there any debate? Gentleman from Frederick.
Thank you, Madam Speaker. Would the floor leader please rise for a few questions?
Floor leader.
Good evening. Thank you, Madam Speaker.
Good evening. My good friend and former prosecutor from Prince George's County.
Yes.
Wonderful. Okay. So I want to understand this bill. It is technical. At the beginning of it, the premise of this bill is so that if someone is in a situation with, let's say, paperwork issues related to immigration, and they happen to go before a court, and they get what's called a probation before judgment, a PBJ, but in order to get a PBJ, you have to do one of two things. You either have to admit guilt, which would be a violation of that immigration issue, or the court has to find sufficient facts to find you guilty, even if you don't admit it, and that would also be a violation. And so what this bill does is it is attempting to address that situation so that someone who, let's say, the courts would like to give probation, but they don't want to violate their immigration status. Is that correct?
That's one aspect of the bill. It's definitely, we're changing it that it would be a justification on the finding of facts, but someone who would want this variation with this legislation on the probation before judgment statute could want it for multiple reasons.
Sure.
Whether it's federal employment, whether not even violating an immigration per se issue, but whether they want it for, they currently have a legal status and it would impact them in that way, like I said, for federal employment. So your premise is correct that there will be situations where someone would want to enter this for that reason, but there are multiple reasons why individuals would want this new variation of our statute.
So how many probation before judgments are issued in Maryland per year, ballpark?
That's a lot. I don't have that on top of my head, but thousands of different PBJs, I would say. I'm looking at my chair. Thousands of different ones are given out every year. Probation before judgments, for those that are not in courtrooms like some of us every day, are issued for many different misdemeanors. I know many individuals on this floor have received probation before judgments, whether that's speeding, so you don't have points on your license. Maybe you were young and you had a trespass issue, or you were consuming alcohol under the age of 21. Probation before judgments are issued every day in Maryland.
Okay. And it's a lot. I mean, there's probably tens of thousands of them per year in Maryland, so it's a lot. So I was reading through the testimony, and I noticed that our court, our state's highest court, the Court of Appeals, had a very lengthy response with concerns with this legislation. And one in particular is that with probation before judgment, the court has to find, findings of fact. They have to read certain rules and rights to the defendant. There's procedure, criminal procedure. The concern I have with this legislation is this is going to create a new category, a separate law where, in the judiciary's words, there's some concern whether there's some constitutional concern, quite frankly, because you're not requiring the defendant to either admit guilt, you're not requiring the court to find guilt, and so how are you going to hold a defendant, one of tens of thousands, hundreds of thousands of Marylanders that get probation before judgment in their state, how are you going to hold them accountable if you haven't found them guilty? How are you going to hold them accountable if they don't admit guilt? It's very concerning.
We're going to hold them accountable because the bill encompasses that. So the amendments that were placed on the bill state, amendment number 2 that was offered and accepted on second reader, that all conditions under law would qualify on this probation before judgment as the one we have in our current statute. So if you violate probation on this form of, if you are going into this form of a PBJ, you can be found guilty by the court. The maximum penalty can be served upon you. It would be like any VOP, like any violation of probation. So all conditions would apply under this, and it is on there's a justification and finding of facts, whether it's a proffer on what happened in the case or not. The court is finding a reason to enter the probation before judgment based on the facts, and the amendments offered helped solidify those concerns from our state's attorneys, from advocates, and the constitutional concerns. So all issues surrounding the probation before judgment, I think were addressed by that amendment that the committee and the floor took.
So I'm just going to read this real quick, and then I'll yield with this. So this was straight from the Court of Appeals, which is Maryland's Supreme Court, for those that don't know. So they wrote, "The bill creates a new way to place a person on probation without first having to enter a guilty finding, but it is unclear whether this new type of plea or new type of disposition, sentencing alternative. This is a serious and fundamental flaw in the bill, which must be addressed. The defendant must enter a plea before the court can simply proceed to sentencing. The court is required to conduct a full examination of the defendant on the record to ensure that the defendant is freely and voluntarily entering the plea with a full understanding of the nature of the charge and the consequences of the plea." These are rudimentary and fundamental constitutional principles. And again, I only bring this up because, in my opinion, if I was a defendant and I had a good attorney, a good defense attorney, like many of our constituents in here, some good defense attorneys in here, and I was lucky enough to get this new type of probation, I would never admit to anything. I wouldn't follow probation. I wouldn't care because I didn't admit to being guilty. They didn't find me guilty on the record. The way I see it is it's concerning for the tens of thousands or near 100,000 PBJs we give per year that these people can get this quasi-probation without any accountability. That's my concern. And I think I share the same concern as the Court of Appeals. I just want to put that on the record.
Sure, and for my my good friend from Frederick, you are talking to a good defense attorney, and I will tell you that you are admitting in the fact that you are waiving your right to appeal. That's what the bill says. You are accepting the terms and the condition of the judgment and your probation. You are submitting to the court that you are accepting all consequences laid out by the state's attorney and what the judge wants to give you. And let me add to this, when you're entering a probation before judgment, that is given by the judge. It is not something, and my good prosecutor friends on the floor know, it's not something they can guarantee. It is helpful when a state's attorney says, defendant A, yes, if you do this, I'd be willing to submit to a probation before judgment. But any judge in the state of Maryland can decide to give it to you or not. That is a risk that you take once you enter that plea agreement. And any good defense attorney, this good defense attorney knows that I talk to the state, I talk to the judge, so that I'm giving the individual the full picture of what they're getting involved with, and that we're getting into this plea deal because the judge has indicated that a probation before judgment will be issued in that case. Everything that you do when you're doing your plea that's delineated in this statute is the same, pretty much parallel to our the older version of our PBJ statute, in which you're waiving all those rights. So the accountability is there. And I think that interpretation, I don't know if that was issued before the amendments were adopted in this case, and I think that it really addresses all concerns.
I enjoy this conversation.
Me too.
I would just say this, and just to reiterate, so unlike a probation before judgment, I'm admitting guilt, or they're finding that there are enough facts to prove me guilty. And so the probation is attached to those facts. So if there's a violation of probation, they're like, don't forget you admitted guilt. Don't forget we found enough evidence to find you guilty when we gave you the probation. And therefore, if you violate the probation, this will not disappear. So for those of you who don't know, the benefit of a probation for judgment is that if there's no additional violations, it kind of disappears. It comes off case search, et cetera. It's probably a good thing, right? My concern here is the defendant's going to say, well, you didn't find me guilty. I didn't admit to being guilty. So I'm not violating anything. And on top of it, God forbid I appeal this, the Court of Appeals has already ruled that there's constitutional issues.
Delegate, I'll just refer you to what I just said 5 minutes ago. You're waiving your right to an appeal. Any good defense attorney as this one would not take a client on saying that they didn't violate their probation, because it's already on record that there was enough facts justifying a finding in which, whatever case that it was, you were issued a probation before judgment. And let me remind you, all Marylanders can enter this type of probation before judgment. And as I said, The Maryland State Bar Association, our State's Attorneys Association, all have been consulted, and even the Good Judiciary Committee has been hearing this bill for the last 4 years in order to make sure every constitutional concern was addressed.
So the last thing I'll say is this. You're basically saying that this bill would allow the courts to put someone on probation without finding them guilty, without them admitting they're guilty, and that is somehow enforceable.
And we do that every day, whether it's an Alford plea, a nolle contendere plea. That's already happening in Maryland law. It's in the statute. That's happening every day. You do that whether you're doing a plea, a proffered on a not guilty, and just a reading of the facts. That's happening every day in Maryland courts right now, Delegate.
Well, but they're finding that there's enough facts to prove guilt. That's the difference.
They're finding a justification of facts, yes.
They're not doing that in this bill, is my point.
They are finding a justification of facts in this bill, Delegate.
Okay. Thank you.
You're welcome.
Is there any further debate? If not, the clerk will call the roll.
Madam Speaker,
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 87 votes in the affirmative, House Bill 559, having received the constitutional majority, is declared passed. Clerk will read the next bill.
House Bill 560.